Showing on this episode of Law Weekly, we look closer at the recently passed Petroleum Industry Act and some of its implications for the country. We have the views of Dayo Kusami, an oil and gas expert and a partner in one of the country's leading law firms. Also showing on this episode of the program, two senior lawyers react to Governor Godwin Obaseki's recent directive that people in Edo State would be required to produce their vaccination cards before they can gain access to certain services or public buildings, plus a recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shieli. After so many starts and stops, the Petroleum Industry Bill has finally become law. On Monday, the 16th of August, President Muhammadu Buhari signed into law the bill, which many say marks a significant milestone for Nigeria's oil and gas industry. Indeed, the Petroleum Industry Act, PIA, is coming more than 50 years after the last legislation, which had become obsolete. So much has been said about the implications of this legislation for the country and its people. But on the show today, I'll give you a fresh perspective. My guest, Dayo Kusami, qualified as a lawyer in 2001. He became partner energy and projects at the law firm Templars in 2009. In 2011, he joined the corporate world as Group General Counsel and Company Secretary of Atlantic Energy, an upstream oil and gas company where he worked out of offices in Lagos, Zurich, and London. In 2015, he went on to serve as an executive director with an indigenous oil service company, providing marine logistics support to energy companies in Nigeria and the wider West African region. And in 2019, he rejoined Templars and has built a sterling reputation as one of Nigeria's leading oil and gas lawyers. I started the interview by getting his comments on the PIA as passed and the committee set up to implement the law.
Well, I think the fact that it's been passed is progress. It's taken a long time and it's finally here. And I usually say it's better a bad law than no law, because whatever faults there are, we can improve with regulation and amendments. But it's here, so it's giving certainty to the industry. That's the most important thing. Regarding the implementation committee, I think it's a smart idea, because often the case is that you have a law passed and there is a transition period with no one actually guiding the boat. So the fact that you have a transition committee that will be, I assume, staffed with those who have industry expertise and knowledge, I think it shows the political will to not just pass it, but get it through and implement it properly. So we would expect industry experts from the government, from NPC, DPR, the regulators. I think it would also be helpful if we had, and I'm not putting myself up for it, but lawyers as well, and people in private as well, who can liaise and interact with the government, so you're having a holistic and realistic implementation of the PIA.
What for you are the highlights of this law as passed? What are the key things that maybe excite you? You know, it's been a long time coming.
It's been a very long time coming. The first time I reviewed a draft of the PIB as it then was 16 years ago. And for a while I said it would never happen. So again, the fact that it's passed, fantastic. Details, the gas, right? You've probably heard it before, we say it, but Nigeria is not an oil company, it's a gas. We're literally sitting on an ocean of gas. And the PIA has a number of fiscal incentives, including the tax-free period that you can get of up to 10 years. Fiscal regime, yeah. Okay. So you could get tax-free fiscal incentives, a tax-free period. There are utilization benefits that are embedded in the PIA. That for me is one of the most exciting things, because that is what can kickstart a proper development of our gas industry.
One of the topical areas that's been up for debate is these oil companies, major oil companies are complaining about taxes and royalties, and then the pushback against the right percentage due to host communities. Yeah. What are your thoughts about that?
So there are two different things. Let's start with the host communities, right? It's become a political issue because, as you know, the PIA, assuming that what will be gazetted is what we saw as the final version, it gives 3% to the host communities.
Which some people have argued is not enough.
Correct. And some might say it's too much. So that's where it becomes a political thing. I don't think it goes down to the quantum. Okay. It's how it's managed. If you recall, the NDDC collects 3% of all oil companies' operating expenditure, right? But there have been questions as has it been appropriately utilized? So if you had 10% and it's not properly utilized, and you had 3% that was properly managed and utilized, I'd rather have the 3%.
Okay.
So I feel that people might always want more, but I think the focus should be on proper utilization. To give you an example, the GMD of NMPC said if you use last year's operating expenditure of oil companies, what that 3% translates to is $500 million a year. Now, if you had $500 million a year invested in host communities, properly managed and distributed, you would see a remarkable difference. So that, for me, it's more how it's applied. To the first question regarding taxes, I'm a corporate lawyer, and I could tell you I don't like taxes. Companies don't like taxes, but there's that old saying, the only thing certain is death and taxes. So a company, while I'm sympathetic to the fact that they should not be overly taxed, if you're operating in a high value environment, taxes must be paid. The important thing is they must be streamlined, open, transparent, and they must be applied properly. So if going back to my point of gas utilization, the tax rate has actually been reduced, right? If you look at on crude oil operations, they've introduced a hydrocarbon tax, which in addition to CETA, if you add both of them, is actually less than the current regime now. So while the government take home, I recognize in some instances can be higher, in most cases the taxes themselves have been reduced.
There's also this issue of state governors threatening to go to court, alleging that the PIA violated the principle of separation of powers. I'm sure you've heard about that. They argue that the act will deny the states their fair share from the federation.
Right.
What do you make of all of those arguments?
I feel that there will be a number of challenges and interpretations of the PIA. There is not one law anywhere in the world that everyone is happy about, and a number of them will be challenged. Right. A number of them, I think people forget that a number of laws come out and regulations are issued afterwards to clarify different points. But to your specific question, every single governor has a responsibility to be able to get as much revenue as they can for their own state. So I understand their position, but it needs to be balanced with the whole national good as well. I'm not really in a position because each governor says different things, but it goes back to the argument of derivation and littoral states. You really should, and I believe that personally, if not professionally, that the communities where we do get the crude oil and gas from should be amongst the most developed in the country. And where that is not the case, I think that's a travesty of justice. So I can understand it from that point of view. But if everyone got what they wanted, no one would get anything at all.
So you would say, sheath your swords, don't go to court yet.
Let's see how it plays out. I would say, let's see how it plays out. There's only a limited amount of money. But here's the thing. If the PIA does what I think it will do, right, the revenues are going to go up so high that so-called small piece would be a small piece of a larger pie. So you have a situation whereas the governors could be complaining that, oh, we're only getting $100 under the PIA. If the PIA spurs investment and that triples, then do they really have a cause to complain? I would argue not.
I know that there are a lot of registers that I am not familiar with.
Right.
There's this one I heard about fossil fuel.
Yes,
and that
fossil
the
fuel.
world is moving away from it.
Correct.
And so some people say that this PIB perhaps is coming too late.
Well, better late than never. And sure, it should have been passed 10 years ago, but what if it wasn't passed 10 years from now? I think cynics say that it should have been passed. Optimists say, well, it has been passed. Fossil fuels, like I said, the PIB has extensive, significant provisions for just gas utilization. So while gas could be deemed a derivative, because you have associated and non-associated gas of fossil fuel, it's not a pure play fossil fuel. Crude oil is, right? So gas is cleaner energy, and there are arguably more provisions and incentives for gas utilization than crude oil. So I would disagree with those that say it's fossil fuel focused, because it's actually forward-looking. The PIA is actually a forward-looking
legislation.
Thank you. Yeah.
So having looked at the act,
Yeah.
have you identified any gaps?
Oh,
so
well,
far?
let me tell you something. It's the easiest thing to do is to criticize, right?
Yeah.
So I will tell you this, based on we've done maybe 5-10 reviews in the last month for different clients.
Before it was passed.
Before it was passed.
Yeah.
Because we sent out a client note. We like to keep our clients up to date with something we call the Templars Legislative Watch, right? We tell them this is a law, this is when we expect it to come out. So we sent out a note saying, in our opinion, the PIB is going to come out summer of 2021, which generated interest. And they say, okay, how is it going to affect our business? Now, what would be a gap for a midstream, upstream, or downstream are entirely different. There are gaps, but I tell you what, the Petroleum Act, 60 years old, had gaps, right? The most current upstream petroleum act in the UK, the US, Australia still has gaps. There will be gaps, and some of them will be clarified or rectified with legislation. That is the normal legislative process. So for me,
So as the more we use it, the more,
the more we
fine
use it,
tune
the more we study it, the more we look at how it is practically implemented.
So in the PIA, there's a provision that 30% of the NNPC profit be allocated to the development of frontier basins, and that has generated a lot of controversy. What do you make of that one?
It has, because I think that there might be a misunderstanding of what frontier basins are. The general consensus when I read the paper that I take away is that people think that this money is being allocated for exploration of oil and gas in the north where there is no oil and gas. So what is going on, as opposed into the south? Now, factually speaking, there are a number of frontier areas or frontier basins. I can tell you for a fact that Anambra has a frontier basin, right? There could be a frontier basin in Ondo State. There is one in Sokoto. So you have...
So even states that do not have oil
Correct.
can have frontier basins.
They can have, because what you have, Nigeria has over 600 million TCF of gas, right? We've only discovered 1/3 of that, about 200 TCF. So a lawyer I admire had said something. He said, Nigeria is sitting on an ocean of gas. So there is still stupendous amounts of natural gas that has not been discovered. If you don't explore, you will never find. So a frontier area is that which has not been explored. Yes, a number of them are in the north, but a number of them are also in the south as well. So what this provision is saying is actually a kind of reinvestment, because NNPC, which will become NNPC Limited, is making provisions. There are also provisions for retained profits, operating expenses, and then remitting the rest to the government. So I think if there's an understanding of what a frontier area is, and knowing that it's not just in the north of the country, it might assuage some concern that people have.
There's the issue of the commercialization
of NNPC. That's something that you've alluded to. How's that going to work?
So the PIA provides that you will incorporate. So NNPC is going to become a private company, registered under the Companies Act. So it will become a private company, and the PIA says this will happen in 6 months. At first, it will be equally owned by the Ministry of Petroleum and the Ministry of Finance. Subsequently, the idea is that based on agreement with the government and approvals, its ownership will be open to the public. This could be either through privatization, through a bid process. There's been no specific mention of an IPO, initial public offering. That would be nice. I'll tell you why. Because it means every Nigerian can own a share in their national. That would be fantastic.
What are the opportunities for lawyers in this? Well, I don't know.
Yeah, in the space.
In the space, yeah. Any new opportunities?
I think it's an extension of already existing. But give you an example. Before the PIA became law, clients were paying me to analyze it. Going forward,
we're going to see a lot more of that.
As a given. So every energy, oil and gas lawyer, even those that are not oil and gas lawyers, are going to have clients saying, what does the PIB mean? Right? Some might try and get it for free, but I advise you to charge for it if you're a lawyer. Right? So there are going to be opportunities there. But then, remember what I said about infrastructure development because of the gas, right? I actually believe that you're going to see in the next 3 to 5 years a marked improvement in infrastructure development. And a firm like Templars can handle all of it, or even the big ones or the medium ones. There's going to be a plethora of work that is going to be spread around because of the PIA and so many projects coming on. So I'm not saying every lawyer has found their golden fleece, but if there's anything that's going to generate more work, it's going to be the PIA.
Welcome back. Now, away from the interview, reactions have not stopped trailing the recent rules rolled out by the governor of Edo State, Godwin Obaseki. At the flag-off ceremony for the second phase of the COVID-19 vaccination exercise held in Benin, the governor said, beginning from the second week of September 2021, large gatherings as well as high-traffic public and private places will only be assessed by persons who have proof of taking at least one dose of the COVID-19 vaccine.
So from the second week of September, people may not be allowed to worship in churches and mosques without showing proof of their vaccination cards at the gates. Similarly, people will not be allowed to event centers for parties or receptions without showing proof of their vaccination cards at the gates of these occasions. We have made adequate arrangements with security to prevent anybody who does not have a vaccination card from accessing any of these events.
Predictably, this has sparked off discussions in so many quarters, with some wondering about the legal implications and how it affects the rights of individuals. I got two senior lawyers to share their views on this issue.
They have this law that Edo State Dangerous Infectious Diseases Emergency Prevention Regulation 2020, which they made pursuant to the powers conferred on the President or the Governor under the Quarantine Act. They went further than most states in ensuring that they took care of restriction of movement, they took care of issue of public spaces, restriction of access to public spaces. What happens even when there is a pandemic and there is a food shortage and you are hoarding essential commodities, food and the what like. So, in their case, they even went further to create an omnibus powers section whereby the governor can do things that are needful as the infectious disease progresses, whatever it is. So, by virtue of, I think it's sections 7, 8, 16, and 18, the governor is empowered to say this is how you would move in public. Most offices, you get there, they tell you no mask, no access. They are not saying you must wear a mask, but if you must come in here, you have to wear a mask. So it is your choice. You want to go to church, you want to go to mosque, you want to go and watch a movie, you want to go and watch soccer, you want to go to the pub to go and drink, you want to go to the nightclub. This is your gate pass. That is your access in addition to what the owner of the facility requires of you. You see, forcing people to take the vaccine, in my view, is when you say, if you do not take the vaccine, you will go to jail. He has not said that. So there are boundaries to all the rights. But more often than not, we want to say, oh, fundamental human rights. They exist, but they have boundaries.
I think the governor is going above the board. He's not getting it right. For the fact that we have COVID and pandemic does not give any person any right to violate people's right without any substantive law. You can, on grounds of public health, do that, but there must be a law. So I now ask some questions, from people in Edo. whether there was any law at any point in time enacted in which this particular issue of certificate, certificate was made a requisite, and nobody, answered in the affirmative. And as I was scared that these governors must not be allowed, because he's setting a dangerous precedent. Other governors all over the country now will begin to now make such pronouncement. You can't make law orally. You can't make law orally in order to derogate rights of individuals. No matter how powerful you are, not the governor, not even the president, under any law whatsoever. So there must be a substantive law that gives that right. The issue of vaccination all over the world, in America, in Britain, is optional. Well, they insist that whenever you're coming into their country, you must, go and be quarantined for a certain number of days before you can mix up, and you'll be tested. And you must show evidence that you have been tested and, proven to be free. That is what is obtainable all over the world now. Now, there is no law that says everyone must be vaccinated in the world today. There is no law that says everyone must be vaccinated in Nigeria. There is no such law. And in any case, we are even having shortages of these particular vaccines. One, you must guarantee that these things are available for everyone. You must also show that there is a law that says everyone can be vaccinated, must be vaccinated. In the absence of such law, in the absence of any law substantively derogating the rights of individuals, in the absence of you making provision of these vaccines all over the place for everyone, you have no right for that pronouncement that was made. It's clearly illegal, and the governor has actually gone overboard. And I think that he should be called to order. And no governor should emulate what he has just said. And I think that the DO people also should challenge that pronouncement of the governor in the law court. It is not right. Before other governors begin to copy that wrong behavior and begin to now impose that you can't even go out of your house, you can't even go to your places of work without showing evidence that you have been vaccinated. It's a wrong pronouncement. There is no such particular law in place today in Nigeria making vaccination compulsory for everyone. There is no such law, and that must be understood. There is no such law that shows the fact that that right you have, freedom of movement, freedom to go and worship God, can be derogated by a substantive law only. There is no such law in existence. And in the absence of such law, I think the governor was actually, trying to probably test the waters to see the reactions of Nigerians. And let us tell it in the language that you understand that he got it wrong. There is no law backing him in that pronouncement he made.
And just before we go, let's bring you a recap of some of the legal stories that made the headlines.
We begin with the report that the Kebbi State High Court on Thursday ordered Prince Uche Secondus to return to his position as the national chairman of the People's Democratic Party. The order came days after he was removed from the post by the order of another court, the High Court in Rivers State, which granted an interim order restraining him from parading or acting as the national chairman of the party. The court in Rivers had also restrained him from calling for the ward, local government or state congresses of the party, or set up committees in that regard pending the hearing and determination of the motion on notice for interlocutory injunction. Presiding Judge Justice Nusirat Umar, sitting in Kebbi, however, said she was satisfied, after reading the affidavit of the respondents, that an interim order should be granted on the purported suspension of Prince Secondus pending the final determination of the case. In Abuja, a federal high court has struck out a suit filed by the Department of State Services seeking to further detain 4 of the 12 aides of Yoruba Nation agitator Sunday Adeyemo, also known as Sunday Igboho. The application was thrown out by Justice Obiora Aguatu following the dramatic withdrawal by counsel to the security agency, Mr. Idowu Awo. The DSS lawyer stunned the court just as the application was about to be heard, announcing his decision not to go ahead with the matter. Rather, he informed the court that he had filed a notice of appeal against the bail granted to 4 of the 12 detainees. The detainees were arrested during a raid in Igboho's home in Ibadan, Oyo State. The security operatives who arrested 12 of them and moved them to Abuja accused them of stockpiling arms to cause chaos in the country. And in Lagos, a federal high court has ordered that a Nigerian, Isiaka Musa, and 2 Guineans, Traore Yakubu and Mohammed Berete, be further remanded in custody for attempting to smuggle large quantities of elephant tusks, pangolin scales, and claws out of Nigeria. The wildlife classified as endangered species were valued at 22.3 billion naira. A 4-count charge was read to the defendants through an interpreter, and they all pleaded not guilty. Justice Tijani Ringim has adjourned to September 1st for the hearing of their bail applications.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shayele. Thank you for watching and see you next week.